Welcome friends to part 10 of the video on elementary logic from first year BA LLB Mumbai University syllabus. In today's video I'm covering analogy as a characteristics of a good and a bad analogy, its use in law, circumstantial evidence as a circumstantial evidence. Analogy in logic and law. Analogy is a form of reasoning. It's a type of reasoning that compares two or more entities or situations based on their similarities to draw a conclusion or infer a relationship or draw an inference. So earlier, in the earlier videos, we had seen deductive reasoning, inductive reasoning. So this is another form of reasoning. Now what is reasoning? I had explained earlier, maybe not, I'm not sure, but reasoning is a form of a thinking. So here when we say reason, we are talking about some kind of valid thinking or valid reasoning or correct reasoning or a logical reasoning. So analogy is a type of a reasoning where we compare two or more things or two or more situations based on their similarity, how similar they are, and thereafter we come to a conclusion based on that relationship. It is commonly used in both everyday reasoning and professional fields like law, science, and philosophy. So, most of us use analogy in our daily lives. Let's see how it is through multiple examples going forward. Characteristics of a good analogy. First, relevance of similarity. So, one of the key features of an analogy was that the the observations should be of similar kind. So, relevance of similarities. The compared entities or situations must share significant and relevant similarities related to the conclusion. So, whatever conclusion we are drawing from these premises based on circumstantial evidence or based on certain observations, they have to have some kind of similarity between them. That is, P premise 1, premise 2, or observation 1, observation 2 for that matter, and the conclusion. So these two must have some kind of similarity so that we can relate thereafter or infer thereafter to the conclusion, which will also be similar to the premises that we have with us. Example, comparing legal principles in two similar court cases. So, court case 1, a certain decision, a particular decision was given. Court case 2, again same type of decision was given. So, therefore, we find some kind of similarity between the judgment of case 1 and the judgment of case 2, and therefore we can conclude in our case, in our particular case, as an advocate or a lawyer, that we will also be able to get a similar kind of judgment in our plaint or in our complaint or in our case. Sufficient similarity. One is that the premises should be relevant or similar in nature. Second is sufficient similarity. The number and the weight of similarities should be substantial, meaning we should have good enough evidence, good enough premises, or good enough number of propositions, not only in the terms of quantity but also in terms of quality. How relevant, how good these premises or propositions are. So the number, the quantity, and the weight of similarity should be substantial. Example, two cases involving the same law and similar facts. When we have two cases and the laws applied in these cases and the facts are very similar, then most probabilistic chances are there that the judgment will be similar in our case also. Absence of critical differences. Differences between the entities should not undermine the analogy. That is, between P1 and these are all entities. Entities are basically individual propositions. So, although they may be similar, but they should not contradict each other also. That is what it's trying to say here. That one, or let's say P1, P2, and there's a P0 also, there's another premise also. So let's say P0 and P1 are very similar. P2 is not that similar in terms of the weight and the number or the quality of that premise, but even then also it should not undermine the truth value of premise 0 and premise 1, or the conclusion also. So absence of critical difference, meaning there should not be any difference between this and this. It is not necessary that they are very similar, but there has to be some kind of similarity. But of course, there should not be critical difference. Critical means a big difference between what the first two premises are stating and the P2 is stating. Logical consistency. For example, the absence of critical differences. Example is analogizing a theft case with a robbery case might fail if the methods used differ significantly. So these are two different kind of cases, robbery cases and theft cases, and we cannot conclude that they are both similar. Logical consistency. The analogy should not contradict the established principles or facts. Although the premises may be relevant to each other, but even then they should not contradict what is already stated as a fact, or which is a fact, or which is known as a fact, or the established principles. So they should also be relevant with those facts or with those principles. That is P0, P1, P2. They could be true, but if they are not connected with those facts or not connected with those established laws, then the conclusion will also be invalid or not correct. Example, an analogy that violates legal precedence is weak. So let's say we have filed a case, and the precedents that we are depending upon in making our case stronger, if that does not directly link or connect with what we are stating, those precedents will not help us. That is, that analogy will violate that legal precedence and it will become weak. Our arguments will become weak. So, what are the characteristics of a bad analogy? Already we have seen what are characteristics of a good analogy. Now we'll go with a bad analogy. Irrelevant similarities. The similarities are superficial or unrelated to the conclusion. Again, P0, P1, premise 1, premise 2, and so on. Let's say even premise 3 also, and then we have conclusion. So, if these are just superficially connected, it means they have no relevance, although it may seem relevant, but yet they may not be similar in nature, and they may not be directly related with the conclusion. So that is a bad analogy in law. Example, comparing contract disputes to a criminal case. When we compare contract dispute are basically civil disputes, whereas criminal case is a criminal liability, civil liability and criminal liability. Simply because both involve human behavior. In both there is a human behavior, but that does not mean that we can compare the contract with the criminal case. Critical difference. Differences between the compared entities undermine the analogy. The differences between the compared entities undermine the analogy. Let's look at it with an example. Equating self-defense with premeditated violence. So when the violence is with an intention, there is a mens rea or actus rea, we cannot say that it is self-defense. So it is violating, or it's going against the principle of similarity. So we need the P0, P1, P2, P3 not contradicting each other. So differences between the compared entities undermine the analogy. The differences between the compared entities undermine the analogy. Next, overgeneralization. The analogy is based on too few instances or oversimplifies the comparison. Example, comparing an isolated legal decision to a universal principle. Emotional appeals. A bad analogy may rely on emotional or rhetorical comparisons rather than logical reasoning. Example, comparing a court fine to modern slavery without valid reasoning. So you cannot give any reason and or basically use emotions, emotional appeals in our uh, agreements or in our complaints. So we have to avoid using emotional appeals, overgeneralization. Critical differences have to be the least, and the similarities between the propositions or between the individual cases should be similar, or entities should be similar. So this is the characteristics of bad analogy. Use of analogy in law. Analogies play a crucial role in legal reasoning, especially when applying principles or precedents to new cases. They are often used in interpreting statutes, analyzing precedents, and presenting arguments. Let's start with the first one, analogical reasoning in precedents. Lawyers and judges often draw analogies between past cases and current cases to justify their decisions. So, when we go to court, both the lawyer we'll see that both lawyers and judges, they used past cases, that is past orders of the judges or past cases or judgments or orders, and the current case as well, to justify that decision. Example, in cases of breach of contract, courts often look at analogous cases, that is similar cases of the past, to determine the liability. Interpretation of laws. Analogies help interpret vague or ambiguous laws by comparing them to more established statutes. Example, interpreting a new law on digital piracy by analogy to traditional piracy laws. Interpretation of laws. What are we studying here right now is the use of analogy in law. So, where do we use analogy in law? We use it for analogical reasoning in precedents. So, wherever we use precedents, we'll use analogical reasoning. We will also use analogical reasoning or analogies to interpret laws. Analogies help interpret vague or ambiguous laws by comparing them to more established statutes. So, basically, we'll compare the various laws. If they are ambiguous or they are vague, then we will compare them with the established statutes. Example, interpreting a new law. If a new law has come on digital piracy, there may be many vague or ambiguous laws mentioned in that. So to overcome that, we may compare that by analogy to traditional privacy laws, sorry. Third, application to circumstantial evidence. Where do we use analogy in law? We use it for in circumstantial evidence. Analogical reasoning is used to draw inferences from circumstantial evidence. I explained what is inference. Inference is the relation between the premise, say 1, 2, 3 premise, and the conclusion. So the relation between the premise or the process of coming to a conclusion from given premises is known as inference. It is the process between premise and conclusion. So analogical reasoning is used to draw inferences from circumstantial evidence. These are probabilistic. We are not certain, like, because this is an inductive reasoning. Example, fact A. The defendant was seen near the crime scene. The defendant had a motive. Fact B. Analogy is similar cases have shown such factors to indicate guilt. Means the person was guilty because he was near the crime scene and he also has a motive. So that basically the lawyer can deduce or come to an inductive reasoning that is showing, or kind of an inference to show that this may indicate some kind of guilt. Conclusion. Circumstantial evidence suggests that the defendant was involved, or the involvement of the defendant. Circumstantial evidence and an analogy. Definition. of circumstantial evidence. What is circumstantial evidence? Evidence that indirectly suggests a fact or conclusion. This is very important to remember. We have evidence. Evidence could be based on facts and conclusions, but circumstantial evidence is basically a fact or a conclusion which is not direct but indirect. Evidence that indirectly suggests a fact or conclusion rather than directly proving it is known as circumstantial evidence, based on circumstances, based on observation. Example, fingerprints at the crime scene is an example of circumstantial evidence. Use of analogy with circumstantial evidence. Lawyers often use analogy to strengthen arguments based on circumstantial evidence by comparing the current case to past cases with similar evidences. Example, in case X, similar circumstantial evidence led to a conviction, therefore it should apply here also. So this is where what is a relation of circumstantial evidence and analogy? So that is by proving that the evidence of a fact or a conclusion is indirect. Even though it may be indirect, it also may lead to a conclusion. And there we use analogy with circumstantial evidence. Let's look at the strengths of using analogy in law. One is it is flexible, it is consistent, and it is persuasive. Flexibility allows the application of established principles to new or unique situations. Consistency ensures decisions align with past rulings, promoting fairness. Persuasiveness helps judges and juries understand complex issues through relatable comparisons. Limitations of using analogy in law. There is a risk of misuse, there is overdependence and ambiguity. When we use analogy, it may represent, if the analogy is weak, it can lead to unjust or biased conclusion. Excessive reliance on analogy can stifle creativity and adaptability in legal reasoning. Some analogies may be too vague or abstract to apply to specific cases. Let's look at question and answers. Define analogy and explain its role in legal reasoning. What is analogy? Analogy is reasoning based on similarities between two entities or cases. This is the definition of analogy. In law, it helps interpret statutes. Analogies help interpret statutes, analyze precedents, and argue cases based on circumstantial evidence. So we use analogy in circumstantial evidence when we don't have evidence based on fact. What are the characteristics of good analogy? There is a relevance of similarity, sufficient similarity, absence of critical differences, and logical consistency. Explain how analogy is used in circumstantial evidence. Analogies are used to draw inferences by comparing current cases to past cases with similar evidence, helping to justify or or draw a conclusion. List the characteristics of a bad analogy. It has, like relevance of similarity, we have irrelevant similarity. So absence of critical difference, so there are critical differences in bad analogy. We have sufficient similarity, whereas here there is overgeneralization, and we also using emotional appeals. Okay, let's go with MCQs. Which of the following is a characteristics of a good analogy? Overgeneralization is not a characteristics of a good analogy. Logical consistency, yes, good analogy. There is a logical consistency. Emotional appeal, we don't use some emotional appeal in this. We should not use. It's a form of a bad analogy. Overgeneralization is also not good. Superficial similarities. Superficial similarities is a bad form of analogy. What is a key weakness of bad analogy? It relies on sufficient similarities. This is a good reasoning, good analogy. It ensures fairness in reasoning. It may rely on irrelevant similarities. Bad and yes, of course, a bad analogy relies on irrelevant similarities. It promotes logical consistency. No. So answer is C. Analogical reasoning is often used in deductive reasoning. We don't use because the conclusion is certain. Interpreting statutes. Yes, analogical reasoning is used in interpreting statutes. Emotional arguments is a bad form of reasoning, and mathematical proofs is a kind of modern symbolic logic. Circumstantial evidence is direct proof of a fact. No, this is deductive reasoning. Evidence, circumstantial evidence. What is it? Evidence suggesting a fact indirectly. Yes, this could be possible. Always conclusive. No, it is not conclusive. It is probabilistic. That is, inductive reasoning is probabilistic. Circumstantial evidence is not always conclusive. There is a probability that it may be false. Irrelevant in legal cases. It is circumstantial evidence is, you cannot say that it is irrelevant in legal. It is relevant in legal cases. So, what is the definition of circumstantial evidence? It is an evidence suggesting a fact indirectly. Okay, a good analogy requires the dash of similarities between cases. A good analogy requires the relevance of similarities between cases. A bad analogy often relies on the dash or superficial comparison. Irrelevant or superficial comparison. So in analogy, so what we will need to remember is that when we are talking about analogy, there is a relevancy or irrelevancy. That is relevant or irrelevant. A good analogy is relevant and a bad analogy is irrelevant. Means dependent, dependable, or not dependable. Analogical reasoning is commonly used to apply dash to new cases, to apply precedents to new cases. Correct. So when we have new cases, there are lot of chances of uh, ambiguous terms or yes, ambiguous terms in new cases. So for that we rely on the precedents uh, to form analogical reasoning. Dash evidence indirectly suggests a fact or conclusion. A fact or indirectly. So this is circumstantial evidence. A dash analogy lacks logical consistency or sufficient. A bad analogy. So this concludes our topic on analogy, characteristics of good and bad analogy, its use in law as circumstantial evidence. Thank you very much for taking out your time and listening. I hope you'll do well in your exams. Best of luck. Also, if you find this video useful, do share it with your friends. Let them also get some kind of help. And logic is difficult to understand for students. I'm also trying my best to understand it step by step. This is also helping me, of course. Thank you very much for staying around and listening. Till the next video. Take care. Bye bye.